Good afternoon, everyone. My name's Brian Zutel. As you heard, I'm a real estate attorney here. I was smiling when Jeremy said, put your phones on silent or vibrate. You know, we usually do that in a lot of different places, church or wherever you are. I went into a courtroom a couple weeks ago, and I haven't had this happen in years. But the judge insisted that all phones must be turned off while you were sitting in his courtroom, and you couldn't use a computer. It was difficult for me. I was grateful that I printed out all my notes and was ready to go. But, I'm not going to require you to turn off your phones right now, okay? So I know you might get that important call. Keep them on vibrate. But let's get going. Again, Brian Zutel, my wife and I have 5 kids. We live locally here in Mission Viejo. And I'm telling you that because my son Joshua, who's 14, was able to join us today. So I'm very grateful to have Josh. And the reason I wanted him to join was because he has an interest in real estate right now. So I wanted him to come to an event and see what it's like. Well, unlike Josh, when I was 14, I had no interest in real estate whatsoever. I thought that I thought they were a bunch of sleazy salespeople at the time. Only on that side of the room, of course. Well, you see, I grew up in the house of an attorney. My dad was an attorney, so everything focused on the law and being an attorney. And then when I was 17, I met this girl, and her family was in real estate. And I started to understand a little bit more about real estate and about all the aspects of real estate. Well, I ended up marrying this girl, Lacey, and her father, my father-in-law, is able to join us today as well, Phil Atwan. So one of the reasons that I got into real estate, he taught me everything I know about 1031 exchanges, tax-deferred exchanges. So he's been very influential. So let's get started. I am an attorney. I'm not your attorney. So anything I say today is focused on the general law. It's not applied to your specific situation. The law is the law. The application of facts to law is a different story, and we want to talk privately about that. Consult with your attorney or consult with an attorney before you make any important decisions in your transactions or in your life. We're focusing on 2026, new year. We're going to go through new forms, new laws, new cases. These are going to be our 3 subjects, our 3 topics today. So, new forms, new laws, new cases. Let's start with the new forms today. New and revised forms. Unlike maybe prior years where I've given this talk, there's not as many, say, new forms, but there are some revisions that we'll talk about to your main body of forms that you're going to want to be aware of, and those primary forms that you use. So let's start with the first one, the buyer, rep, and broker compensation agreement. Buyer representation and broker compensation agreement. You might know, if you've been in the business any more than, say, a year or two, that this is a very important form, and this has gone through a lot of different revisions over the years. It's not as drastic this year, but there are a few things to be aware of. So added to the BRBC is the... Nope, I take it back. This is your preview. This is the BRBC. We're going to talk about the RAD form, RAD. We're going to talk about the RLA, Residential Listing Agreement, and we're going to talk about the RPA, the Residential Purchase Agreement. So let's start with the BRBC. As you might know, this was recently mandated by law. Addition of a statute to the Civil Code, along with the settlement, along with a lot of other things. This is now a mandatory thing to use if you want to get paid. I don't know about you. I like to get paid for my work. Hopefully you do as well. So if you want to get paid, you need to be using this form. Now, as you might know or you might have heard, there is a set time limit on this form. There is a set number of days that this agreement can be in place. That has recently been interpreted or has been regulated to be 90 days. So when you're using a BRBC, it is a 90-day window. It is 90 days that this BRBC can be effective. So how long can it be effective? 90 days. How much is 90 days? 90 days is 90 days. There was this ongoing, is it 3 months, is it 90 days? No, I'm telling you that though because I'm not emphasizing the 90 days versus 3 months. I'm telling you 90 days means 90 days, not 180 days, not 365 days. It means 90 days. This is super important. It doesn't matter how hard you're going to work. It doesn't matter how difficult the buyer is. It doesn't matter where you're traveling around the county. You could be traveling all Southern California. It doesn't matter the buyer's getting their sale property into shape. It doesn't matter they're working on their financing. 90 days on this form means 90 days. And I'm emphasizing this because a couple weeks ago I got an unfortunate call from an agent who was doing a consultation, who was calling me and wanted to hear more about if her BRBC could be enforced. We were going along, she was describing the situation, then she told me those death knell words of, oh, it was a 180-day BRBC. I said, oh boy, I'm sorry to tell you, you will not be able to enforce your BRBC. You have worked for free. I'm sorry to tell you. And she wanted to go on and tell me that she worked so hard, the buyer was very difficult, the buyer was getting their property ready for sale, all these things, and I had to tell her, I'm sorry. The law says, Civil Code 1670.50 says, a buyer-broker representation agreement that is made in violation of this statute is void and unenforceable. I'm very sorry to tell you this. And even tell her, I think your broker gave you bad advice. I'll leave that to them. But I'm sorry to tell you, you will not be able to enforce that BRBC. So what do you do instead of the 90 days? What do you do instead if you need 180 days? If it's going to take you a whole year, make the 90 days the set term of the BRBC, and then renew it every time. There's a form for that. Use the renewal. No automatic renewals, that's a no-no, but put it on renewal each time. Just keep sending that renewal to your buyer as you're working with them, and that way you'll be protected. You won't work for free.
What's the name of that form?
I don't remember. I knew it. I meant to put it on there. I know, right? Stumped them. Yeah, stumped them. See me later. I do know what it is. Remember the exception to this, if it's a corporation, LLC, or partnership, there's an exception to the Civil Code statute here. One more and then I'm going to keep going. Kelly.
Can you use a modification of terms?
Can you use a modification of terms? Last I looked at the modification of terms, I don't remember if they added the BRBC as one of the forms that it should apply to. You can use there's a modification form. Again, it's been a busy month. I didn't get down all the forms. There is a modification of the BRBC form that's in there that allows you to modify specifically the BRBC provisions. Let me save your questions. Let me keep going from this. There's also a disclosure for the referral fee, the RAD form that's included now as a part of the BRBC. So if you check that box, it'll automatically insert the RAD form in there, and you'll be able to use that form. We'll talk about the RAD form in just a minute. So residential listing agreement form, the RLA, of course, very important when listing a property. There's now a disclosure also added with regard to referral fees and the use of the RAD form into section C5 of the RLA. So again, if you check that box, and we'll talk about what's on the RAD form in a minute, but if you check that box, it'll auto-populate in there and you'll make certain disclosures that are very important to be making. There is also, you might have heard about this, the digitally altered images statute and MLS rule that we'll talk about in a minute, but this is now added to the RLA. So you ask, what is a digitally altered image? If you all pull up your website right now and you have that photo from 20 years ago on there, you know exactly what a digitally altered image is. Now, a digitally altered image is not exactly defined, but, there we go. The advertisement or promotional marketing materials must include reasonably conspicuous statement that the image is altered, and also clearly identifying that the original unaltered image can be accessed via a public website. So this is from the statute. And so, the legislature, of course, came up with this. So if you have a digitally altered image that you're placing on there, now remember, we're not talking you cleaned up the color a little bit, you worked with the contrast, you did a little bit of amateur Photoshop work. Anything that I could do on an image is not going to be a digitally altered image on Photoshop. But if you are removing power poles, let's say, from the backyard, if you are removing a wall that cuts off part of the property, if you are substantially altering the layout of the property, that's going to be a digitally altered image. You definitely need to disclose that that is an altered image and include the link to the original. Also, the CRMLS rule 11.5.2, if an agent includes a digitally enhanced image in the listing, they must also include the original unaltered image next to it with the disclosure about the digitally enhanced images to indicate they've been edited. So CRMLS, I think they're going to start enforcing this more and more just as a warning, so make sure that you're including the unaltered image there along with in the photo description of CRMLS, add in what is required here about the digitally altered image.
That includes virtual staging.
The virtual staging is an interesting one because, it's like you could go into the property, you clearly see there's not a couch, there's not a table. I would include it. I would definitely, you asked the question. I would include, if you are using virtual staging, because of where we're going in the current climate and everything going on, yes, include a little byline, include a little description. This is virtual staging. It'll just keep you safer. All right, so now we're moving to the RAD form, the Realtor Acknowledgement and Disclosures form. This is a new form that's come out. It's not new procedure. It's not new law. All of these things should have been done by you in the past. All of these things were required by Code of Ethics or the law in the past, but now it's all been drawn into one form for your use. So the Realtor Acknowledgement, the RAD form, includes a statement for people to say, I am or am not a realtor following the Code of Ethics. Now, I was scratching my head when I was putting this together because I thought that non-realtors are not supposed to have access to the forms. There's a way in which non-realtors can actually get access to the form. There's a way to purchase access to the database without being a realtor. I guess if, the idea is if they're using the forms and they're making this disclosure, they need to say, I am not a realtor, but I'm using the realtor forms. Okay. Hopefully all you are realtors, you're following the Code of Ethics. I don't know that I want to use a realtor that doesn't follow the Code of Ethics, but that's a different thing. Because
you were an unrepresented buyer.
An unrepresented buyer, maybe, yeah. There's a few scenarios here. The next one, let me keep moving this form, says, I pride myself on how hard I work for you and I try to resolve all issues. So contact me if you have an issue, Mr. Buyer, Mr. Seller, or contact my broker to resolve issues. Great. You think anybody's going to read that? Probably not, but it's there in the form. Now this is where it starts to get important because this is one of the main uses of the form. Compensation from multiple sources. So if you're being compensated from perhaps somebody outside of the buyer and seller circle, this is a place to disclose it. And then again, this was part of the Code of Ethics. If you intend to, if you have, or if you're a part of the buyer group, buyer entity, buyer partnership that is purchasing the property, you have to disclose a present or potential ownership interest in the property. So this is the form that you will use. I'm representing a seller as an attorney right now. Buyers have submitted an offer. I did a little bit of research, a little bit of digging, found out, oh wait, Mr. Buyer, you are certainly involved with this LLC that's purchasing it. So let's make your disclosure. This form just came out 2 months ago, December. So not everybody's familiar with it, but this buyer had to make the disclosure, and then I discussed that with the seller as to, is he okay with proceeding with the buyer agent who's representing the buyer entity, and the buyer agent has an interest in that entity. It was fine, but this is where you make that disclosure. Now, the most important one, probably the one you've heard the most about, is the referral fee section on the RAD form to make that disclosure. So if you or your broker are receiving a referral fee or paying a referral fee, you must disclose that on the RAD form. That's a referral fee. Now, that's different from a sharing of the commission, a sharing of the compensation. A co-brokerage, where two brokers perhaps are working together for one side or the other, that's a different situation. This is where I pass off John Doe to new agent, and John Doe works with new agent to close the transaction. So that is the referral fee that needs to be disclosed, and you'll disclose that using the RAD form. Last form, the residential purchase agreement, the RPA, which seems to grow every year. I don't know how many pages we're up to now. I think it's 19 or 20 now. I remember when I got in the industry, it was 8 pages. I've had people tell me they remember 2 pages. So we're adding a new section now. So here's the important disclosure. You ready? The electrical system inspection advice disclosure, which informs your clients. Maybe you should get an inspection of the electrical system, including the panel. Is everybody very informed now? Is everybody going to be disclosing this to their clients? Are you going to be referring to page 9 of 20 or wherever it is on there? It's a new part of the form. It's increasing the length of the form, but now it's disclosed. You should get an inspection of the electrical system. Great. That's it for new forms. That's not it for new forms. That's my focus on new forms. So I just focused on the top 4. Of course, there's plenty of other changes elsewhere, but just so you're aware, those are the main 4 forms and the biggest changes. Let's talk about new laws. New laws. So, pop quiz. How many bills were signed by Governor Newsom last year? Throw it out. Too many. 900? I hear 900, 900, 900. Final number, probably 800. About 800 bills. I think it was 796 this year, which is much better than the previous year, which was about 1,000. So, hey, we're getting a little better here. About 800 bills signed by Governor Newsom last year. There's about 50 of these laws or so, 50 or so that affect real estate. We're not going to talk about 50. We're going to talk about a few, all right? We're going to go into substance on a few of them, and then I'm just going to give you real brief highlights on a few of them. So, all right, let's talk balconies. So, you know the balcony inspection. You've heard this every year. Here we are again. They kept pushing back that deadline, pushing it back. Well, that deadline finally came and finally stuck, right? This applies. The balcony inspection rule applies if the building has 3 or more dwelling units and an elevated structure built of wood or wood-type products, I think is what it says. If you have that, it requires an inspection of, quote, exterior elevated element, balconies, decks, porches, stairways, walkways, entry structures that extend beyond the exterior walls and has a walking surface 6 or more feet above the ground level. So this is the requirement. Now the implementation of it, again, was pushed back, but here we are. Condo associations were required to comply with this 1/1/25. All others were required 1/1/26. And we're in February 2026 now. So what kind of compliance do you think there's been? Well, it's been pretty difficult from what I've heard. The people that do these have been very impacted and been very backed up. So who can do this? Who is the inspector? A licensed structural engineer, civil engineer, or an architect, or for apartment buildings, a general contractor or a certified building inspector. And then there was this recent addition for asbestos. If asbestos is found, there can be an extension of a number of months on that inspection. Now, the issue I'm sure that you've run into, right, is the HOAs. The HOAs that are required to disclose that most recent balcony inspection report. There was that ambiguity for a while. Should they disclose it? Can they disclose it? The law is clear now. The HOA is required by law to disclose the most recent balcony inspection report. So there should be no pushback from the HOA about providing that most recent balcony inspection report. There's also a suggestion that they really do have to provide all balcony inspection reports for inspection. Now, I'm not clear looking at it whether that just means you go into the HOA manager's office and you can read them, but you can't get copies. Not totally clear. There's a requirement for all balcony inspection reports available for inspection. And then within that, the HOA must identify any immediate safety threats from the balconies. And that'll be on that summary form that you get of the HOA.
How often are they required to inspect, to have the inspection?
6, you keep coming up with questions I didn't look, I know. I think it was 6 years when I heard last, yes.
The report is good for 6 years.
The report is good for 6 years, essentially, yes. But double check that. All right, so a few new laws. I'm just going to do miscellaneous. We're going to run through these really quick. If you want to talk more about them, we can talk later. But a disclosure of third-hand smoke residue. You might have heard of this. Smoke residue, if the seller is aware of. That's the requirement for disclosures. If the seller is aware of third-hand smoke residue, that must be disclosed now via the SPQ. There's a new Zone 0 that's being suggested and researched and probably will be implemented for fire hardening. Again, a complicated area we won't go too much into. The new fridge and stove requirement for rentals. You might have heard about this, right? Whenever a landlord on a new rental now must provide a stove, okay, I think that one makes sense, but a fridge. The landlord must provide a fridge, okay? There's certain ways to thread this. It says fridge, it doesn't say freezer, but you know, I don't know if you want to mess around with that, but there is a requirement that the landlord now provide a fridge for any new rentals. Electronic return of security deposits. From what I heard, most landlords are doing it this way anyway, but now it provides that this is the default unless stated otherwise, electronic return of security deposits. And a requirement, this is particularly important for us. We do a lot of litigation, so there's a requirement for photos of service when doing substituted service of process. So if you have any landlord clients who are trying to do their own evictions and serving via substituted service is now a requirement for photos. That's a complicated area. I won't get into it, but it's important for landlords doing evictions. Just a couple others real quick. These are new-ish laws. Landlord-tenant. I talked about these last year, but now they're fully in place. Move-in, move-out photos, cleaning photos for security deposit deductions. That's important. You must have photos if landlords are going to be deducting from that security deposit over a threshold amount. Implemented, that was from last year, but it's now implemented. No automatic deductions from the security deposit. No carpet cleaning deductions from the security deposit. Each thing needs to be spelled out. It needs to be actually incurred by the landlord. Unlawful detainers. Now unlawful detainers, they used to be 5 business days. Now they're 10 business days for the tenants to respond. So at least when we're talking to potential landlord clients, I'm usually telling them now, you really need to be more hard-nosed. Rent is due on the 1st, is late on the 6th. You should be getting the notice to pay rent or quit out on the 7th. And that, unless you just love your tenant, you really do need to start playing more hardball, because this process will take a while. In Orange County, the evictions right now, we're at about 2 to 3 months. In LA, you're looking 4 to 5 months. So you really need to be playing hardball and keeping this timeline moving if you want your unit back. And the trade-off for this was the motion to dismiss timeline got shortened, but I won't go into that. Okay, not new laws. These are prior report, not new laws, but prior reports and repairs. This has been the law for decades, and this has been in the SPQ and the TDS, in the SPQ specifically for a long time. But now CAR is very much emphasizing this, and we see this all the time in our litigation business. And this has to do with non-disclosures in a purchase and sale transaction. There's a duty, this duty's been around for decades in California. There's a duty to disclose material facts. The seller has a duty to disclose material facts in the sale of the property. But the SPQ for a long, long time has also required disclosure of repairs and alterations. I mean, it's right there, and it has no timeline on it. People just skip that, or maybe they're moving too quickly, but it does say, are you, seller, aware of any prior repairs or alterations? I mean, if you have a homeowner who's owned for 20 years, you better believe they have something to disclose in terms of a repair or alteration. The SPQ also requires that the seller provide copies of any documents relative to the property that they have in their possession, relative to any prior repairs, alterations, improvements, and other things. Those should be provided to the buyer. The seller must disclose any previously repaired defects and past inspection reports. If you had a transaction fall out of escrow and you're on escrow number 2, you need to be providing a copy of the inspection report from transaction number 1. It doesn't matter how long ago the repair was made. I had a client maybe almost 10 years ago. Guy was meticulous about keeping documents. He'd lived there 15 years, and he had a whole file cabinet of all the documents about all the repairs. He had receipts, he had invoices, he had instruction manuals for everything. And he came to me and said, "Do you want me to give you all this?" And my first response is, "No, I really don't want your file cabinet of stuff." The second response was, "Yes, we do need that. You do need to turn that over. You do need to provide this to the buyers." So that's the requirement. It's been there for a long time, but CAR is beginning to focus on it a little bit more. And remember, real estate brokers must retain documents for 3 years after a transaction. So if you have an inspection report from a transaction, you need to retain it for 3 years. If you get that same client selling in year number 2, you have an inspection report in your possession that needs to be provided along with that seller in the 2-year transaction. So that is the real estate retention requirement. That's the laws. Let me do one case and then I'll take questions. So generally, again, this is just overview. You know there's a lot of ongoing federal and state litigation. The issue of buyer's claims is still not resolved. Remember, the Missouri case dealt with sellers. The issue of buyers and buyers' claims that realtors are cheating the system and increasing the price of homes, that's still making its way through the system. There are multiple federal cases ongoing with that. That's not resolved yet. The DOJ continues to file what are called statements of information in certain cases that they're interested in. That means the DOJ says, we're not a party to this, but we're watching this case. They just filed one a couple of weeks ago in a Zillow Compass dispute. So they're watching these things, and they might, step in if they think it's worthwhile. And then the FTC recently, 8 months ago, I think it was, they filed FTC versus Zillow and Redfin, claiming that they were promoting anti-competition with some of their agreements between Zillow and Redfin. So a lot of ongoing stuff. Here's the one case I wanted to go over with you. This was kind of interesting. This came out 2 weeks ago. This is not a reported case, so it's not official law that I would cite to, but it kind of gives you an indication of the current climate and what you should be doing. This is the case of AgCon versus Cornerstone Financial. This was in San Bernardino County. I think it was in Adelanto. AgCon, the seller agrees to sell vacant land to Frontier, the buyer, for $460,000. And there's an individual named, I'm going to say Pocius. I don't know how to say his name, but Pocius is the broker for the buyer. Pocius learns during the transaction of a potential rezoning of this property to allow for some form of either cannabis distribution or growth or something like that. He just learns about this through the ongoing city council meetings and the potential, again, for the rezoning of this property. Well, the transaction closes at the $460,000, and shortly thereafter, AgCon, the seller, sues Frontier and Pocius. So you're probably wondering, what did they get sued for? Well, what did Pocius do wrong to get sued? The allegation was that as a broker to a real estate transaction, Pocius owed AgCon the following duties. Now, you know these. These are on all your forms. You've seen these before, I hope. I hope you have these memorized. You owe 3 duties in a transaction: a duty of diligent exercise of reasonable skill and care, a duty of honest and fair dealing and good faith, and a duty to disclose all facts known to the agent materially affecting the value or desirability of the property, not known to within the diligent attention and observation of the parties. So you might expect that the seller focused on number 3 there, the duty to disclose all known facts. That's a common one to focus on. They did focus on that mostly, and then Judge Winston Key in San Bernardino, who was a very good judge, very attuned to the facts of the law, he said, no, they don't have a duty to do that. So he granted what's called a non-suit. He said, we're not going to take this issue to the jury. I'm deciding this as a matter of law. There was no violation of duty here. And you, seller, you lose. You lose against the broker. Well, they appealed, and the Court of Appeal a couple weeks ago wrote this, that Judge Key had wrongly decided the issue and should have sent it to the jury because a jury could reasonably find that these emails during this timeline show that at a minimum, Pocius knew the city was considering rezoning AgCon's property to allow for cannabis cultivation in the upcoming months. Although that was not guaranteed, a jury could reasonably find that it was unfair, dishonest, or in bad faith for Pocius not to tell AgCon of this possibility while simultaneously representing Frontier. So what did he do wrong? He didn't inform of a possibility of potential rezoning that would have increased the value of the property.
But he can't renegotiate the price.
This is what the Court of Appeal says. I'm sorry, guys, that's really tough for you. And I'm just being honest. To inform of possibilities that are learned of in ongoing city council meetings for decisions that haven't even taken place yet. And the Court of Appeal says, no, a jury could find that Pocius was dishonest, unfair, and acted in bad faith. So, anyways, what's the old adage? Disclose, disclose, disclose. And you might even have to be disclosing potentials, what ifs, to cover your back. You really should be disclosing anything you know. Now again, this is not law yet. This is what's called an unpublished case. It's not going to be cited. But this is the current climate that you're dealing with. This is the current climate of what people think of realtors and real estate. So make sure that you are disclosing everything that you know, including potentials. With that, there's my contact info. My assistant Cindy is over here. Angie, our associate attorney, is over here. They joined us today. You feel free to talk to them. I'm here, and I can take questions. Okay.
Well, we're going to ask one. Let's really give a round of applause to Josh, Brian's son, that actually made it through this whole thing. Josh, you did great. I mean, what a day for you, right? Yeah, a lot to intake here, 14 years old. So we're going to ask a couple questions. If you can, not shout it out, would be great, but if it comes out, I get it. So, Brian, ask one question. I can't think of it. I mean, here's my question. Who do you put on the contract for escrow? Well, there we go. Okay, there's one.
Quick story. Generations. So, okay, I trust Generations too for complicated legal ones that we get into. We have one even right now where there's a lawsuit ongoing between buyer and seller. We agreed to this complicated settlement, and we shipped it over to Generations to handle because I don't want to be chasing that buyer and the seller for this complicated buyback transaction that we have going. So Generations escrow is wonderful, and we use them as well for complicated transactions. Question.
So for the case that you just mentioned, the agent is obligated to disclose because he's a dual agent, right?
You know, I looked. So the question is, was the agent required to disclose because he's a dual agent?
Does anybody know the answer?
He was a dual agent, though. Yes.
Oh, this is complicated.
If you're a dual agent, you better believe that this wouldn't have been as close. I looked through the opinion. I read through it. The Court of Appeal, again, they moved too fast or it didn't come to them. It wasn't clear whether he was a dual agent or not. If you're a dual agent, you better believe you're disclosing this. I don't think he was, based upon what I read. I think he only represented the buyer, and I think the seller was unrepresented as far as I read it. The Court of Appeal didn't write the greatest opinion, my opinion. But even when he wasn't representing the seller, he got sued by the seller, and this is what the Court of Appeal found: that he acted in bad faith, unfairly, and whatever else they said. So disclose.
Okay.
I hear you. I mean, the comment is he couldn't have raised the price because they already had a purchase agreement. You're right. But the suggestion was almost that Pocious in the beginning should have said, hey, I'd like to buy that property for $460,000, but I know it's going to be rezoned shortly for cannabis cultivation. I know it's going to be worth $800,000, but I'd really like to buy it from you for $460,000. This is the fantasy world that the Court of Appeal came up with. My opinion.
Thank you, Brian. It was amazing. And reach out if you need anything.